Estelle Griswold and Planned Parenthood opened a birth control clinic in Connecticut, knowing well that they were exposing themselves to prosecution under a law that prohibited not merely the sale, but the use of contraceptives. She knew what she was doing in opening up that clinic, and she expected to have an opportunity to challenge the constitutionality of the law before the Supreme Court. The dispute is whether the states have an inherent power to identify and proscribe activities that they consider to be immoral, and if there is inherent limits on state power to criminalize or otherwise restrict access to information, medicine, and means of promoting the health and safety of people in the context of reproductive activity. Griswold made a number of arguments. The more attractive argument was the idea that there was a right of privacy, that the state could not invade simply by saying, this is immoral, we don't like it, let's get rid of it. Of course, a hurdle to that argument is that there's no expressly spelled out right to privacy in the Constitution. Connecticut's side of the argument was pretty straightforward. States have a reserved power to protect health, safety, and morals that has been recognized since the founding. The people of Connecticut think that contraceptive use, even by married couples, is immoral. Therefore, we have the power to prohibit that. They said that Griswold wasn't in any position to argue for the right of privacy because she wanted to open a birth control clinic in public. The court sided with Griswold and held that the Connecticut statute could not constitutionally be applied to married couples. Justice Douglas's opinion for the courts, he was assigned to write the opinion of the courts, was generally regarded as a total mess. He's a very smart guy, but he's not very disciplined. Douglas cites virtually every amendment under the sun other than the Due Process Clause of the 14th Amendment. What he does is he infers from a bunch of textually listed rights, a right of privacy, that he then uses to strike down the statutes, totally avoid the Due Process Clause, and leave a lot of people just scratching their heads with his famous penumbras and emanations metaphor. Justice Harlan, writing separately, is very focused on liberty as guaranteed by the Due Process Clause, and he thinks that this is a straightforward case. The right of married couples to use contraceptives is within his understanding of common law liberty. Let's not make this complicated by gesturing to all of these other amendments. What it established was that there was a right to privacy that included the rights to engage in some measure of intimate activity that definitely included married couples, but did not necessarily include unmarried couples. And then you have the dissenters. Justice Hugo Black, who says only rights that were specifically enumerated in the Constitution were protected by the Constitution. It was as simple as that for him. Justice Stewart just generally agreed with Connecticut that there are certain things that states just need to be able to do that are silly in the name of morality, and unless they did something that was particularly egregious, it was okay. Griswold v. Connecticut is one of the most important constitutional decisions that the court has ever reached. It recognizes a right that is widely valued by Americans associated with the Constitution, and they believe that they have. It is also, in the opinion of most legal professionals, not particularly well written or reasoned. But for better or worse, that's where we are. And if and when Griswold is challenged by states who are seeking to go beyond banning abortion to forms of contraception, the court will have to decide whether the weakness of the initial opinion justifies dislodging a right that I think is properly rooted in a good, solid understanding of the original limits on state governments and widely valued by Americans.